Welcome all in another exciting session of Simplifying Law by Advocate Vyoma Deshpande, representing my law firm AV Legal Associates. In today's session, we are going to understand the importance of will, how it has to be drafted carefully, what are the critical insights in drafting and execution of will, and how to draft a legally valid binding will. So before going further, the most common question asked in reference to drafting of will is what are the advantages of drafting will? So first and foremost advantage is it gives clarity in distribution of property. So estate administration is very critical aspect. So when you are going ahead with taking care of your future generation, I think the best way to secure the future of your younger generation is to draft a will, wherein you are consolidating all your properties and making your intention explicitly clear to whom you want to give the property, why you want to give property to a particular person, why you don't want to give property to anyone else. If you have any intentions of donations or some social obligations, then those aspects can also be very well taken care of as far as will is concerned. The second advantage of drafting will is it avoids the dispute between legal heirs. Generally, in India, we find that there are many disputes amongst legal heirs after the death of a person, and basically most of these disputes relate with ownership of property. So you want your children to reside peacefully, having healthy and cordial relationship amongst themselves. It is better that you execute the will. So it is your wish, your children have to follow that, they have to obey that. So there will be less chances of disputes amongst legal heirs once the will is executed. Third and most important aspect is it gives certainty in distribution of property. Now, why this certainty is essential? See, whenever we are dealing with reference to ownership of property or devolution of interest in the property, then we have to make it sure that it is properly worded, it is aptly mentioned, and there are no ambiguities, there is no scope for confusion. Although will is a form of testamentary succession, yet a proper distribution by way of one comprehensive document, there is a guarantee or there is at least an assurance that there is a certainty which will avoid any scope for any double meaning, any multiple interpretations, and it will secure the future of your younger generation. Last and most important aspect is that suppose a particular person wants to disqualify any of his legal heirs from inheritance, then also will is very helpful. I have seen number of cases in these days wherein a son has refused to take the responsibility of parents after attaining a particular age. So in most of the cases, there are daughters who are looking after the welfare and maintenance of their parents. In that case, if there is any anguish between a father and a son or parents and son, and if they want that the son is not entitled to inherit the property, then they can make a will and can exclude such disqualifying son from inheriting the property. So there are multiple advantages of creating a documentary proof with reference to distribution of property, and estate administration can very well be taken care of by drafting will. So these are the advantages of drafting will. Now comes the second crucial aspect is about essential ingredients of will. Although it seems that drafting of will is a very trivial task, it is not so, because the every word we mention in the will carries with it some weight. It has some interpretation. So if we mention a wrong word, then it will have a wrong implication, and your intention to give a particular property to a particular person may not be fulfilled. So what are these essential ingredients of will? First, we have to properly mention name, age, occupation and address of the person executing the will. all these things have to be sufficiently mentioned, including the proper spellings of that particular person. If the spelling on the Aadhaar card or the KYC document is different, if the name on the will or the spelling mentioned in the will about the name of a particular person is different from those appearing in KYC document, then it again creates a scope for interpretation. So in order to avoid that, we have to check what is the procedure or what are the words a particular person has mentioned even while describing his own name in the KYC document, and we have to parallelly check that in will we are mentioning the same name of that particular person who is executing the will. Second is second important aspect is we have to write a brief life history of the person executing the will. Now you will ask, what does it mean by the life history of a person? So life history basically comprises of when a person, what is the birth date of a person, what is the birthplace of a person, what is his primary school, what is his secondary school, the name of secondary school, when did he get married, who are the children, the names of children, and any significant or milestone achievement a person has achieved during his lifetime. So a small bio or a small description of a person has to be included in the life history of a person. So you will ask me, what is the need of mentioning the life history of a person? So basically, if I write a life history in my will about my birthplace, birth date, the date of my marriage, the date of birth of my children, then it gives an impression that at the time of executing will, I was in sound physical and mental health to remember the important events of my life. Now it is very essential. In order to will become valid and legal instrument, it has to be executed by a person who is of sound mind. So this soundness of mind, how we are going to ascertain the soundness of mind? Of course, we will be annexing the medical certificate to the will. That is one part of it. But writing a proper brief life history will be an additional advantage to show that the person who executed the will was in fit physical and mental state, and he was in a sound position to remember the important events of his life so as to exercise a judgment to whom he wants to give the property in will. So therefore, don't forget to mention the life history of a person. Second is list of movable and immovable properties. Now as far as immovable properties are concerned, we are very well aware that our flat, bungalow, land, any type of landed property we can mention in list of immovable properties. Now in list of movable properties, what all details are required? In movable properties, we can mention details about our bank accounts, sufficiently giving idea about the bank name, branch name, account number. If it is shares and mutual funds, then it has to be properly worded about the number of that share certificate or folio number along with the name of the company who has issued those shares. People are investing in cryptocurrencies, although it is a gray area about how crypto is going to appreciate or give results in the future. If there is something that we can mention as abundantly clear as possible, we have to include all these things in the will. Apart from that, ornaments. Now while describing the ornaments, the nature of ornaments has to be written. Say for example, 4 bangles, 1 neck piece, 1 ear piece, whatever be the description, coupled with the weight, approximate weight. It need not be a correct arithmetic description of weight, but it will be a sound description so that we can identify that particular ornament depending on that description. So ornaments have to be mentioned in the list of movable properties. Some of the families have some antique pieces in their home, so it is some valuable asset. Apart from that, if there is anything that is valuable, cherishable, and you want to pass on that particular property to a particular person, then don't forget to mention those details in your will. So these are the basic distinction between how we have to list out between movable properties and immovable properties. Going ahead, we have to decide about the flow on distribution of property, like who will be the beneficiaries under the will. If your children are going to inherit the property after your death as per your wish, then in what proportion they will inherit? Who will get what type of property? Why a particular property is not given to a particular legal heir? What are your intentions behind executing the will? You have to sufficiently explain all these details in your will. Suppose there are more daughters, there are more than 2 or 3 children, then how they are going to inherit those particular properties? All these details need to be sufficiently explained in your will. That will give no rise to ambiguity and confusion about who is going to inherit what. So while executing the will, we have to make sure that the future generation will be troubled less in terms of inheriting the property. It has to be a smooth, hassle-free and very friendly way of inheriting the property if the will is carefully drafted. So after mentioning the flow and distribution of property, if you feel that the properties are very big and if you feel that there is a probability amongst the beneficiaries about disputes on who will take what, then you can even appoint an executor in your will. Appointing an executor in the will create an additional benefit. Now, who is executor and what is his role? So the executor is the person who will control, or rather who will look after the fact that the property will be given to all the beneficiaries as mentioned in your will. The person who is of younger age than the person who has executed the will has to be preferred. So executor need to be younger in age so that tomorrow when the will be open for execution, he must be in a position to give effect to the intentions of testator. So the executor will look after the intentions of testator in the will and will see to it that those intentions are carried forward or executed peacefully without any disturbance. So the executor will, in short, will execute the will as per the intentions mentioned in the will. This is how the role of executor is played. Next is medical certificate. A will has to be compulsorily attested with a medical certificate. Now, if I am saying it has to be compulsorily attested, meaning that tomorrow there should not be any challenge on the mental or physical capacity of the testator. Having a sound mind of a person before executing the will or at the time of executing the will is an essential ingredient of valid, legal and binding will. So what is the best proof of showing that a soundness of a mind or a competency of a person to execute the will is to annex the medical certificate. Now in medical certificate also, what should be the ideal contents to be included? So here comes the role of an advocate also, that what words an advocate will suggest to the doctor. Of course, the doctor will definitely conduct his own medical examination of that particular person. But having said that, what are the essential words that has to be included in the medical certificate? Do check on those words also, so that there will not be any scope for any confusion or ambiguity. Last but not least is signature of witnesses. Now, ideally it is said that a will has to be attested by a signature of 2 competent witnesses. So the 2 competent witnesses who will see you that you have signed the will or you have understood that the will is getting executed. This is very important. So tomorrow if the witnesses are called in the court, they must be in a position to tell that yes, we have seen the testator has executed this will. It should not be a case that we were not aware when this will was executed, or we have not seen the testator whether he has read the will or not. So the attesting witness must be some credible persons who will come forward and will testify on this point that yes, the will was made by the testator. We have seen him understanding the nature and effect of that particular instrument, and he has signed it. So witnesses plays very important role in proving the will. Even as far as age of witness is concerned, we recommend having the younger age of witnesses. So suppose for example a person is executing the will at the age of 55 years. So we presume that the will get opened after 10 years or 15 years. So if the witness is of age of 58 year or 68 years, then there is a less possibility that the witness will remain present at the time of execution or the opening of will. So therefore it is always recommended that the witness should be of younger age, so that they will be in a position to come to court if need be, verify the fact that the will was executed. So these are the basic essentials for draft of will. Now there are some critical insights that we have to take into consideration in all these processes. First and foremost important aspect is no stamp duty and registration is mandatory for will. So as I have said, will is not a transfer of immovable property. Will is a mode of testamentary succession, and there is no compulsory stamp duty payable on will, and even registration of will is not mandatory. Having said that, I honestly feel that getting the document registered or getting the document at least notarized will create some good value to that particular instrument, because a person can execute as many wills as he wants during his lifetime. In that case, his latest will prevail. But having said that, I recommend going for registration or notarization of will to give that additional weightage to will. But law does not make any difference between a registered will and an unregistered will. But definitely I will recommend for going for registration or notarization of will. Secondly, avoid ambiguous or uncertain words in the will. It has to be clean, plain testament. There need not be any jargon of words that have to be used in the will. I remember in one of my cases that I have handled, the wording was that the possession of the property to be transferred in the favor of beneficiary. I don't know in what context they may have written this, but it created again a scope for confusion and doubt whether the testator really wanted to pass on that property to the beneficiary to the fullest. Why the word is possession only written? Why it is not written that the property is given in will to that particular beneficiary? So it gives a scope for confusion and ambiguity. Therefore, I recommend using clear, plain and simple words and understand the difference between possession, ownership. If we are using those particular words, then these words carry some meaning. So if we are saying only possession, that means we do not want to enjoy beneficiary that particular property in fullest sense, or he should have only possessory rights. That can be an interpretation. So avoid using such type of sentences or words which creates confusion in testamentary succession. So another important aspect is don't forget to mention all your properties. One of my clients have inquired with me that whether I can execute a will only with reference to one of my bungalows. So it is not advisable, because you cannot execute multiple wills for your multiple properties. Generally, will is considered to be the last testament of a person. So for that last testament, if you are creating multiple documents, then it is going to set a wrong precedent. It is not even expected. So mention all your properties in the will. Don't forget to mention any important properties while mentioning the testament. And apart from that, you can have a generic clause in the will that if any of the property is found in the future which is in your name and which may not have been mentioned or which has not been mentioned in the will, then how the testament is going to be created in the favor of that particular property. Please also mention such a generic clause to secure the future of your younger generation. The next important aspect is understand the difference between nomination and ownership. This is the most commonly asked question, that people say that we have made the nominees, so there is no need of drafting or executing the will. So it is a settled principle of law that nomination does not confer ownership. So whenever there is a nominee appointed, the nominee will take that property and further will ensure that who are the legal heirs of that particular person, and it is the responsibility of the nominee to ensure that the property is further given to the legal heirs of the deceased person. So don't confuse the concept of nomination with ownership. Nomination does not confer ownership. And last but not least, if you want to exclude some person from inheriting a particular property or from your testament, then give sufficient explanation as to why you are excluding a particular person or a particular legal heir from the testament. What is the need? You have to sufficiently explain that so that there will not be a scope for any confusion, ambiguity or double meaning. That will make the things very crystal clear, and your intention of executing an instrument for the benefit of your future generation will be secured. Now people feel that we can use again online draft for executing the will. So I strongly oppose this concept of using online draft for executing the will. Will is a very important document. All your property that you have hardened throughout your life is going to pass on to your younger generation. So don't consider it is a very simple and small affair that you can use an online draft and get it executed. It is not that simple. Having a particular word may lead to multiple interpretations and you don't know what is the choice of word you are doing. It is a matter of an expert person who will guide you about how the testament has to be properly reflected in the will. So take the help of advocates and get ensured that you are executing a valid, legal, effective will. Thank you for this session. Let's meet in another exciting session.